we're back. And you know what? We've done so many episodes. I don't remember what number we're on. I don't think it matters. I'm realizing with this, I'm going to have fun with it, not try to be so perfect because I can't be. You know, I have such a precious gift today, and I have Bridget on here. And she has done so much for my community that I live in, a community that I love. And I always know that when people are working with Bridget, they're safe. And that really matters to me. I may have the smallest referral list out there, and that's okay. Because if I'm not going to use the person that I send people to, then I'm not going to send people to that person. And I know we all make mistakes. We do. But today I want to talk about something, and I sort of added this to the mix today, and that's about trust, because I don't know anything about trust. Look, I don't want people to think when they call me I'm some expert. I ask questions. That's what I do, because I want to get people the right answers. And when it comes to the law, that's why you go to the right person. So tell me a little bit about trust, where we start. And, you know, I don't know how many trusts are out there, but how do they help us, and what do you recommend?
So there's a couple of different trusts that I would say that we use or I use on a regular basis. One is a revocable trust, which is a trust that you set up during your lifetime to hold all of your assets so that when you pass away, your assets will transfer outside of the probate process to the individuals that you've named in the plan, how you want it to transfer to them, and when you want it to transfer to them. So the biggest difference between a revocable trust and a will is that if that trust properly holds your assets, there will not be a probate when you pass away.
Oh,
So that's the most frequently used one that I use. We also use a lot of special needs trusts in our practice, and those are set up for individuals, either first party or third party. For individuals who are receiving any type of government assistance like SSI or Medicaid, because they're only allowed to have a certain amount of assets in their name, and otherwise they could have their their benefits limited or be kicked off of their benefits. So it's something that I see that happens quite frequently. In our attorney listserv is always reaching out saying, I have a special needs client who's received an inheritance from their great aunt and it's going outright to them. How do we protect their benefits? So very important in our documents, we always have a trigger for supplemental needs. So before we distribute anything to a beneficiary, we make sure they're not receiving any type of government benefits where if we gave them an outright distribution, it would kick them off. If you have that beneficiary, we then have the option to set up a third-party special needs trust for them.
now, what is the difference between a South Carolina ABLE account versus a special needs trust? Can you explain the difference? And
Yes, so
if you have both?
so the ABLE account allows the special needs individual to accumulate assets, have more than that $2,000 typically in their name. It started a few years ago, and it's a way for them to accumulate some assets and be able to have those assets, but under guidelines of the federal government so that it doesn't disturb their benefits. A special needs trust is a trust where somebody else administers the account for the recipient and would be in charge of that. So technically the assets are not available to them unless the trustee is distributing. Where an ABLE account, they can get access to those assets.
My next question, and I'm trying to figure out how to articulate this question, because I want everyone to understand that Bridget, being one of the best attorneys in the Carolinas, and we'll say South Carolina since North Carolina, you guys can't hire. She has to eat and she has to make a living. So when I say this, it's just a question. I want to understand that, because when some of us are struggling, but we still need these things, is this something the average person that's struggling can get? or is this only something that the wealthy could get? But that by no
Mm-hmm.
means that anybody, including Bridget, should ever work for free because she has to make a living. But what do we all need to get? Because just because we're struggling doesn't mean we should always struggle. We should still have a
Right.
plan, right?
Right. It also doesn't mean that you're not going to have an unfortunate accident and be, incompetent or incapacitated for a long or short period of time. And you should have someone set up to handle things for you. For you, Rachel, you have a business that needs to be managed if God forbid something happens to you. Somebody needs to pay your bills, all of those things. So
Right.
everyone should be able to afford some kind of plan that is going to protect them for the situation that they're in. So not everyone needs the same plan, but everybody needs a plan.
Right.
Mm.
And maybe we're looking at what our spending habits are, sitting down.
Mhm.
Because some of
Right,
the things that we're buying, we may not, that's not going to protect us,
right,
right?
right. It's
Certain
about
things.
Right. It's about decisions that you make and what you think is valuable for you and your family. I know it's hard for a lot of young families to even think about putting an estate plan in place, but they're almost as vulnerable as our senior population because they have young children that if they don't come home one day after work, that child's life is hanging in the balance, so to speak, because who's going to take care of them? Maybe there's an agreement between, for example, if it were my daughter, an agreement between us and her that we would take the children. But that's not a legal plan, and that there may be other grandparents that want to, fight for custody. So it's a huge, huge issue that one, families think is for older people, or two, they don't feel as though they can afford a plan or even want to have the conversation. I know it sounds strange, but I've encountered some folks who are afraid if they put a plan in place today, they're going to have to use it in a short amount of time.
That does sound strange to me.
It does, but that's their feelings and those are their
Right.
feelings, and we just have to do our best to educate them and help them get more comfortable realizing that I can't make any guarantees about anything, especially not the day that you're going to pass or anything like that, because I don't have a crystal ball. But statistics show that if you put a plan in place, most people outlive their plan by several years.
Now, what about wills? Can you just talk briefly about wills and why we should all have a will?
So a will transfers your property at death. So there are many ways to transfer property at death. You can own it jointly with someone and have it pass through survivorship rights. You can have beneficiary designations on your life insurance, your bank accounts, all of that. Those avoid probate. But a will passes your probate assets. So anything that you own individually when you die that does not have a beneficiary or joint owner on it. So, for example, I tell a lot of married couples that if we use a will plan, we can usually avoid probate at the death of the first spouse because everything's owned jointly or they're each other's beneficiary. But when the second spouse dies and it's passing on to their loved ones, there's going to be a probate. Some assets we can put beneficiaries on, but a house we cannot. So the house is definitely going to go through probate, might be the only assets that goes through probate, but there will be a probate. And one of the misconceptions is I hear it all the time. I have a will and you're telling me I still have to go to probate. Well, we say a will is an invitation to probate because if you have a will and you have an asset you own in your own name, you will have to go to probate. It
That
doesn't
helps.
stop you from going to probate.
I have learned so much. I have learned so much, but let me tell you, I'm still sending people to you because I certainly don't know as much. And I want people to really understand that. Please stay away from $100 will or a $200 will that you see. Don't let AI do anything for you.
Oh, God. No,
No, we're
no,
not there today. And
no.
full disclosure, today I had questions to ask and I I asked AI to help me with it, and there were some mistakes with just
Yeah.
writing questions. You can't replace people when it comes to these issues. Yes, AI is amazing in so many ways, but it's not going to replace the what if. And if this happens, what do you do next? It's not cut and dry. And that's what I'm hearing today.
Yeah, absolutely. I've put into AI draft me a will for South Carolina, and might it work? Probably in some cases, but I don't know if it would work for everyone. I know it wouldn't work for everyone because it doesn't know the nuances. And I've also typed in legal questions, and gotten some information that sounded like it was right, but in reality, when you look at the laws in South Carolina, it was contradictory to what the law said. So we have a ways to go with AI before we're depending on it completely for our life.
Right. And this is too serious. This is
Yeah.
just too serious.
Yeah.
Well, I appreciate that. Thank you for sharing more information about wills and writing a will and a trust and
Mhm.
why it's so important. And for the final episode, I'm looking forward to learning more about Bridget as a person and her legacy. But a lot of this is her legacy that we've been talking about. And I just love your passion, Bridget, and I will see you on the next episode.